I'm Srini Devadas. It's my pleasure to introduce Jonathan Kaplan, who was the first master's student whose thesis I ever read in 1989. He worked with Jonathan Allen, who was the director of the Research Lab of Electronics, got his master's degree in electrical engineering and computer science from here in 89. Then got a law degree from New York School of Law in 1992 and has been practicing law ever since. And now lives in Portland, Oregon, and runs his own law practice. And Jonathan is going to talk about, I guess, the variety of legal careers that folks who get tech degrees can pursue.
Thank you very much. Thank you. So I hope this will be of help to you. Joe Cote, who is one of the alumni who I'm speaking about today, he just wanted me to let you know, when I talk about admitted California, New York, Washington, USPTO, you have to be admitted to each individual state where you'd like to practice law. So that's why that's the way it's written. And then to actually represent somebody before the U.S. Patent and Trademark Office, which is what USPTO stands for, there's an additional bar for that, but that's only one test nationwide. So I'm going to try to, let me just give my standard disclaimer that this does not constitute legal advice or other professional advice. If such legal or professional advice is needed, you should obviously seek the appropriate professional. The questions that I'm going to address today are, what kinds of legal careers are open to someone with an MIT degree? How do I know if a legal career would be a good fit for me? And what skills would I need in order to succeed in a legal career? Obviously, you've already demonstrated considerable science and engineering skills. I'm just going to begin by making you aware of some of the other resources available right now at the Institute that I've come to know about in the process of preparing for this report. There's been a long-term course by Dr. Robert Rines. He gives an undergraduate and a graduate version that focuses on inventions and patents. And he has obviously a very enormously interesting and impressive background. So you might want to seek him out as well. There's also a center at MIT for technology, policy, and industrial development, which is run by Dr. Joel Moses, acting director. And they have quite a broad mission to look at technology strategies and policy issues. They have a number of research programs. And you can see that one of them actually is a law and technology program. So that's kind of interesting. And Professor Nicholas Ashford is the director of that program. There is also, of course, the MIT Careers Office. And there actually is a dedicated pre-law advisor, Tamara Mengi. You might wish to seek her out. My main law school advice is prepare thoroughly before taking the LSAT, which stands for Law School Aptitude Test. Just a quick piece of advice, because it's just not a test you want to take lightly. Just don't do it on a whim, because I was actually surprised when I applied to law schools. It's by far the most important single data point in your application process. So it's kind of incredible. Also, I just want to note that there are certainly other additional Institute resources that are probably available to you, which I simply don't know about. So I don't want to represent that as a complete list. I thought it would be interesting to look at some data on what MIT students have been doing in the past. So I spoke with the Institutional Research Office, which keeps these types of records. And the last time they did a comprehensive survey was not that long ago, 2005. They did 5 different class years. And you can see that actually a substantial number of MIT graduates, these are people who are undergrads here, ultimately do obtain a JD or a law degree. It looks like the steady state has been about 5% over the long term. Of course, other areas are higher. Medical is higher. Master's in business is higher. Now, if we look specifically at the EECS department, we can see, for example, that the class of 1988, 8.8% received JDs, which I thought was sort of a surprising number. Now, there's also data on who is currently taking a degree. And we can see that at that time, currently enrolled, there were quite substantial percentages of the classes enrolled in JD or LLB course degrees at that time. 1983 was 10%. This is institute-wide. Now, if we look at EECS, we can see that it was a lot lower at the time of the survey, but significantly, you can see the class of 1998, 16.7% EECS was enrolled in a law program, and 6.7% of the 2003. So it seems like there's something of a trend there. This kind of was my takeaway from the data. Now I'm going to give a brief overview of the career types that I'm going to cover today. These are all IP-related careers, basically because that's my background. That's why I went into law. But I'm covering a broad range, far beyond what I myself do. We're going to talk about what's called the in-house intellectual property counsel. We're going to talk about, generally speaking, a judicial officer, which is somebody who decides controversies, a technology licensing specialist, outside IP counsel, litigation specialist, and then finally my own area, which is outside IP counsel, non-litigation. So just to briefly introduce these types, an in-house counsel is a lawyer who basically just has one client, which is the company that he or she works for. The company needs to have a certain level of maturity because obviously they're not going to be able to support that kind of a support person if it's not of a certain size. A technology licensing specialist negotiates a particular category of agreement. Outside counsel, litigation specialist. In general, outside counsel allow in-house counsel to outsource the legal services they need. And this is economically efficient if the service is highly specialized and or only periodically needed. So since IP litigation, and particularly patent litigation, is extremely complex and expensive, and relatively rare for each individual company, this is an ideal candidate for IP outsourcing. It's probably the most commonly and widely done IP task by outside law firms. Outside IP counsel in the non-litigation area, that would be basically could do really anything the in-house counsel might do, but that they might prefer to outsource for one reason or another. This would include what are called opinions, which are basically legal advice on a threatened or ongoing litigation, prosecution, which I'll go into a little more later, which is basically obtaining patents or trademarks from a patent or trademark office, and due diligence, which is our investigations as part of a corporate transaction to make sure everything is just right. I'm also going to talk about some of the common threads between the careers that we're covering today. They all address the issue of translating technology to the broader society. I think that's one common thread. They all provide a middle ground between careers that are more focused on technology and others that are more focused on business. So a key advantage of legal careers are that in general, you'll have the opportunity to work with a much broader spectrum of technologies. The corollary downside is that in any one technical area, you'll have less depth, less focus, and you will not be creating new technologies, but you'll be interfacing with those who do. And I also would like to note here that while the legal careers I'm presenting today all involve IP, there are, of course, many other types of legal careers that you might want to consider, which don't necessarily involve intellectual property, but would also use your technology background. And that's a trend I think that's only going to continue given the increasing importance of science and technology to our society. Certainly it's going to be more intertwined with science, and laws are going to be more intertwined with science and technology. Some characteristics for effective lawyering. Ask yourself, do you have strong human language skills, particularly writing ability? Do you like to write? That's basically what a lawyer does. They're working with a lot of language all the time, reading and writing. And you need to be able to express yourself with what I would call targeted clarity. In other words, you need to be able to be clear where it serves your client's interests and not so clear where it doesn't serve their interests. I'm glad I got a laugh out of that one. But I'm trying to be straightforward with you here. I'm trying to give you some inside advice. So, and it's hard to find people who have both very strong, solid science and technology backgrounds and have a strong facility with language and like language. You need to have an interest in being an advocate and in arguing. A lot of people, they aren't interested in that. You need to have an ability for and an interest in negotiation. And that means, can you see both sides of an issue and reach an accommodation on the issue? And even in litigation, the overwhelming majority of litigations, which is the most contentious area of law, they settle. So you do need to know how to reach an accommodation in law. Good speaking skills are also important. Can you think on your feet, so to speak? But even so, there's a lot that you can do in law by writing. But obviously, speaking on your feet is an asset. Before I go too much farther, what is intellectual property? I'm not going to try to take too much for granted here. So just generally speaking, it transforms what would otherwise be a work of the mind into a property right that's legally recognized. And there are four main types. There are patents, which protect the application of engineering or scientific principles. There are trade secrets, which can be for almost anything, really can be a trade secret. And there's copyright, which protects the expression, the particular way that an idea is expressed, and that's why it's used a lot for protecting content and entertainment and informational content. It applies relatively limitedly to software. And then there's a trademark, which basically just identifies, just a mark or a sign that identifies the source of goods or services. What are the three major modes by which people work with intellectual property? Well, the three modes are basically creation, which is the IP has to be created. This is done mainly by non-lawyers, by the scientists or engineers or authors. But lawyers may be involved in creating, well, they are involved in creating the property right, particularly for patents and trademarks, where you have to prepare an application according to very complicated rules and procedures, and you have to argue just to obtain the property right to speak with in the first place. For things like a copyright, you basically just register it as a clerical task. Then the second area is what's called enforcement, and that's where, of course, a property right is of no value if you can't actually enforce it. So there's either actual litigation, and this is what I think most of you probably think of when you think of lawyers, and that's because it's a very dramatic form of practice, and it makes good film and television. And appearance in court of opposing parties before a judge or a judicial officer. But there's also a lot of what I call near litigation work, where a lawyer provides advice on an actual or potential litigation. And that can be a party that's either planning to sue or is concerned about being sued, and they'd like some opinions on the merits of the situation. Or it can be a party that's already been sued and wants an opinion on how to avoid further litigation. So that's creation and enforcement. And then finally, there's what's called exploitation, which is the formation of agreements to allow one party to use or benefit from the IP rights of another party. And that occurs in what's called licensing of IP, changes in ownership of a company, which can require what's called IP due diligence, financings of a company, either through an IPO or a private placement. Those are situations that also can require due diligence. So now that I've given you, hopefully in just a few minutes, I've given you sort of a thumbnail sketch of intellectual property and how people work with it and the careers. Now I'm going to go step by step through the 5 different career types. The first one being in-house IP counsel. So let's put that within our framework of creation, enforcement, and exploitation. So an in-house IP department addresses the full range of IP responsibilities. You'll deal with creation, enforcement, and exploitation. So in terms of creation, you're going to have to deal with employment agreements. How do you keep the creative people that are producing a lot of the IP? How do you keep them happy? How do you keep them at the company? Patent prosecution, obtaining patents, obtaining trademarks, procedures to keep things secret so that you actually have trade secrets and things that you haven't patented, making sure copyrights are registered. Enforcement, a very important task of in-house IP counsel. There are constant, particularly if it's a significant company, there are constantly incoming threats of potential lawsuits that have to be evaluated. And in-house counsel have to determine the appropriate level of response. There's actual litigation. Usually you're managing outside IP counsel who actually do the litigation. You have to provide counseling and formal opinions. These can be outsourced to outside IP counsel. And finally, in the exploitation area, you would be dealing with licensing agreements. For example, if you're a software company, basically the way you sell your product is by selling a license. That's, in some sense, the product. If you're a larger company, you'll be doing due diligence investigations as they acquire smaller companies. And you'll also be participating in what are called standard-setting organizations, such as the IEEE. Have many different standards. So let's do a brief comparison of in-house IP counsel to outside IP counsel. As I kind of alluded to before, the major advantage of in-house role is because you have only one client, your relationship to that client is very deep, much deeper than outside counsel is able to enjoy. So you develop a deep understanding of the industry in which your client operates. Who are the major competitors? What is the economic ecosystem in which your client and its competitors operate? You develop a deep understanding of the company itself. What are its main value-add technologies? Who are the key employees and how do I keep them productive? What kinds of strategic advising do the corporate officers need? You're responsible for relations with various governmental authorities, keeping the patent office educated and informed, providing input on important legislation. For example, just this past year, there's been the Patent Reform Act of 2007, which would have been one of the most significant changes to the patent law since 1952. It looks like at this point it's not going to happen this year, but there are many in-house IP counsel giving important input on this. And then there are trade issues with the government as well. Can you transport technology across borders? Dealing with what are called International Trade Commission actions to prevent importation. And finally, you have management of outside counsel as a very important role. And here I have an example. Just to make this, I think, a little more interesting, I'm presenting an example MIT alumnus. So these are people that were one of you. So we have Michelle Lee, who was in EECS, and she's now Associate General Counsel and Head of Patents and Patent Strategy for Google. She obtained the BSEE and MS degrees in 1989. And she says that as an undergraduate, she enjoyed Course 6 because she enjoyed calculus and physics, and she loved Maxwell's equations. She pursued a master's in the computer science area because of involvement with the Hewlett-Packard research labs, and she was awarded a National Science Foundation fellowship for those graduate studies. She says, "I certainly did not attend MIT with the idea of becoming an intellectual property lawyer, but she did become aware of what was a very famous case, Apple v. Microsoft, in copyright infringement. And this is one of the cases that kind of established how copyright could be applied in the computer area. And she became aware that there were some very interesting cutting-edge issues in intellectual property law, and she felt that she could make a valuable contribution in this area. So, and then she took Robert Rines' class, which I mentioned earlier, on patents and innovation, and that kind of confirmed her interest. And let's see, prior to Google, she attended Stanford Law School. She had 2 different clerkships, one with the Northern District of California, which is known for doing a lot of technology cases, of course, as you would think, and also the U.S. Court of Appeals for the Federal Circuit, which we'll address a little more later. And that also is a very heavy technology-oriented court. So then she became a partner at a well-known Silicon Valley firm, Fenwick and West, and then in 2003 started at Google. So second career type is a judicial officer. And for that type, before I delve into a specific career, I'm just going to give a brief overview of our adjudication system in the U.S. Basically, there are 3 different kinds of forums for adjudicating disputes. We have state courts, we have what are the federal courts, which are organized under the federal Constitution, and we have then basically various administrative law judges, which are with agencies, federal agencies that have been created. So the state courts can hear trademark and trade secret issues, and often do. But as pure creations of federal law, patents and copyright cases are heard only in the federal courts. The federal agencies, there are some of the better-known agencies for IP are the U.S. Patent and Trademark Office, which has what's called a Board of Appeals and Interferences, which basically is if your patent application is being denied in the normal course of examination, you can kind of appeal what the patent examiner is saying to a board. And then ultimately, if that board doesn't agree with you, then you can take your appeal up to a federal district court, and then to a circuit court, which would be the federal circuit, or you can go directly to the federal circuit. So there's a lot of judicial oversight of these agencies. There's the U.S. International Trade Commission, which deals with basically preventing importation that would constitute patent, trademark, or copyright infringement. So these are some of the forums. The U.S. federal courts are organized in 3 tiers. There are the district courts, where you have the actual trials. And there are the courts of appeal, where you have a right to appeal your trial to. That is your first level of appeal. There are 13. They're called circuit courts. The 1st to 11th circuits are geographically organized. The states are put into groups, and each group of states has its own circuit. And most important among those for today's talk is the Federal Circuit, which hears all appeals from any U.S. district court where the original action included a complaint arising under the patent laws. And then finally, there's the Supreme Court, which is the final level of appeal, but the Supreme Court doesn't have to hear your appeal. It's up to them, and most of the time they will not take your appeal. They will only grant what's called a writ of certiorari if there's a conflict between the circuits below them, or if they feel there's a substantial question of law. The Federal Circuit was created by Congress in 1982 to promote greater consistency in the patent law. And as I mentioned, it hears all appeals from the district courts that arise under the patent laws. It has exclusive jurisdiction to hear issues from the U.S. Patent and Trademark Office, from the Court of International Trade, and the International Trade Commission. It consists of 12 judges appointed by the president with the advice and consent of the Senate. And in 2007, for example, 37% of its adjudicated cases involved IP, 35% patent, and 2% trademark.
What was the other 63%?
A variety of cases. It has a lot of, for example, Veterans Affairs on its dockets, which is not, it's. I think it was created as something, as a lot of things, was created as something of a compromise, a political compromise. So a bunch of other things were kind of put under this court's jurisdiction in order to have the original law passed. Our example alumnus is Kimberly Moore. She is a circuit court judge with the Court of Appeals for the Federal Circuit. Extremely impressive judicial position. And she obtained her BSEE and MS in Course 6 in 1990 and 1991. She worked summers in IAP at the Naval Surface Warfare Center and feels that it gave her great real-world experience. She also, like Michelle Lee, she took Robert Rines' course on patent law and innovation, and that was very influential to her in leading her that way. Her advice for EECS students, electrical engineering background is one of the most useful you can have in intellectual property. The technology is moving very quickly. And electrical engineering, in addition to being great subject matter, teaches, of course, wonderful, rigorous analytical skills that will be useful for anything. Her legal career prior to being a Federal Circuit judge, she went to Georgetown University Law Center. She was in private practice for a couple of years at Kirkland & Ellis, a very well-known law firm. And she had a clerkship on the Court of Appeals for the Federal Circuit with Glenn Archer, who was the senior judge at the time. He was the chief judge at the time, and currently he's what's called a senior judge with a somewhat scaled-down docket cases. She then went into teaching, and it seems that her career path was to be a law professor. Another career you can think about, because there's a lot of demand for IP professors, law professors. She was at Chicago-Kent College of Law, University of Maryland School of Law, and then finally at George Mason, where she became an associate and then a professor of law. And then, and she published and presented widely on patent litigation and on the Federal Circuit. And then, basically to her surprise, she was nominated in 2006 by the President to the Court of Appeals for the Federal Circuit. And she actually is the youngest judge currently serving on the federal judiciary. And that includes all the circuit courts and all the district courts. So it's kind of amazing. I talked with her about job opportunities, and she points out that you really can't plan to be a federal judge because you do have to be appointed. But you can plan to be what's called a judicial clerk. And that basically is a position that lasts for 1 or 2 years. And you would do that either immediately after law school or within a few years of law school. And you basically can assist a judge in their decision-making process. And Kimberly describes it as a fabulous opportunity to get behind the scenes and to really understand a court's process and the judge decision-making. Responsibilities include explaining the facts of the case to the judge. This is particularly important in cases that involve complex technology issues like patent cases. You'll do legal research, informing the judge on latest trends in the law. You'll prepare draft decisions for the judge. And Judge Moore thinks she learned more in her 2 years of clerking than she would have in 10 years of private practice as a lawyer. And she pointed out that there are many MIT graduates have clerked for the Federal Circuit, that they're highly desired by the Federal Circuit judges. And there are new clerks are sought each year because it is a relatively short-term position. There are spots for about 40 clerks on the Federal Circuit. it is best to have some law firm experience before applying. It's better to work for a private law firm for at least a couple of years. There are other courts where technical degrees are sought. There's the Court of Federal Claims, U.S. Court of International Trade, which I mentioned earlier. A number of the federal district courts have become known for patent cases, such as the Northern District of California, which I mentioned earlier, also Massachusetts, right in this area. Eastern District of Texas has become a magnet for patent cases. So those are other courts where you could be a clerk. There are also administrative law opportunities at the International Trade Commission, which I mentioned before, and within the USPTO, the Board of Appeals, Patent Appeals and Interferences, which has 72 members right now and is looking to expand. And of course, as I mentioned before, a law professorship is a very attainable goal, and law schools are always looking for more IP professors. The third career type I'm going to address is technology licensing specialist. As I say, I'm not going to assume much. So I'm going to explain to you what I mean by a license. Basically, it's a kind of legally binding agreement. It's really a variety of what you call a contract, and what I'm talking about here are private grants as opposed to a license from a government, like a marriage license. So it's a private grant from one party, the licensor, to another party, the licensee, of a right to use some intellectual property. And a license can enable the licensee to produce products or services that would use the IP, or to manufacture products or services, or to sell activities that would otherwise be infringing if there were not a license. A license can be exclusive or non-exclusive. If it's exclusive, it puts an obligation on the licensor, the holder of the IP, not to license other parties, not to produce other licensees that might compete with the one licensee, or it can be non-exclusive. A licensee's rights can be limited in a variety of ways. You can limit the license geographically to certain states, for example. You can limit it in duration. You can limit to a field of use. It's really, you can be very creative in licensing because the right to draft contracts is very, very broad. And there is a difference between what's called an assignment and a license. An assignment basically is if enough rights have been transferred, then it'll be treated as an assignment, or more colloquially, a sale of the IP. But I'm not really going to go into sales of IP in this talk. I think it's beyond the scope of this talk. But if the receiving party of the rights has the right to sue, in other words, the right to initiate a lawsuit on the IP, then they would typically be considered, or almost always be regarded as having had an assignment. Let me just point out here that the negotiation and formation of technology licenses does not require the practice of law. So this is kind of a unique, quote, career in law, because you don't really have to go to law school at all. And in fact, most technology licensing specialists haven't gone to law school. So that's definitely a feature of this type of career path. It does require a sophisticated understanding of legal issues. So you'll learn a lot of contract law, a lot of patent law, and you do need to work with lawyers often. Technology licensing can be divided into two main spheres, what I would call academic technology transfer and corporate technology transfer. And this division is reflected in two of the largest technology licensing societies. There's something called AUTUM, which is the Association of University Technology Managers, and then there's LES, the Licensing Executive Society. So AUTUM seeks to promote, support, and improve academic technology transfer. Licensing Executive Society is much more professionally and commercially oriented, corporate technology transfer oriented. So those are two good societies to know about if you have any interest in this area. I'm now going to talk a little more about academic technology transfer. That is founded on something called the Bayh-Dole Act of 1980, which founded modern technology transfer. And basically what it did is it allowed academic institutions that are receiving U.S. government funding to own the IP that they produce. So it really gives them something to sell and gives them an incentive. And so as a result, many academic institutions created offices of technology licensing or technology transfer to try to exploit, exploitation being an activity that we defined earlier, to exploit the IP they create. But academic exploitation is characterized by an emphasis on promoting the public good and thereby justifying further funding of the educational institutions. To achieve the exploitation, academic institutions also engage in creation of IP, which we talked about earlier, such as patent prosecution, and enforcement occasionally, litigation, for example, of a patent. Vast majority of academic licensing is exclusive because basically you want to give a particular party a strong incentive to take some very early stage technology and put it out there. So on the other hand, there are benchmarks that go with the license, and if the company can't meet the proper schedule, they can lose the license. A unique characteristic of academic licensing is that if no one licenses the IP, it is often the case that the technology will never, quote, see the light of day because it is so embryonic. And Alida Nelson, who is the director of MIT's own technology licensing office, she has characterized this as one of the unique gaps in academic licensing. Basically, how do you take a PhD thesis to the point where business investors will commit resources to it? There's a big gap there, and that's still an issue that I think everyone in this field is trying to address more effectively. Once a deal process has been started, however, it's almost always the case that the licensee really wants that exclusive license. And so thus, in academic licensing, both parties want the deal to be done, and it occurs in a very positive atmosphere. In contrast, that is not always the case in corporate licensing, where a licensee may prefer that a license is not necessary. Now I'm going to talk a bit about corporate technology transfer. Why would you license IP in the corporate environment? Well, there are a variety of reasons. You might want to create new revenue streams. There might be cost advantages by minimizing R&D spending. And this is a very common trend. I've heard of this a lot recently. For example, even companies like Procter & Gamble. It used to be the NIH philosophy, which is not invented here, we're not interested. But that seems to be changing a lot. And companies are really looking to license technology rather than having to have their own budgets to develop it. It can allow you to freedom to operate within a particular technology space that you'd like to move into. It can establish alliances and further a relationship. It's important. Sometimes companies need to do spin-outs, startups, or other new ventures. It can restrict your competition. That's very important too. And it can be used to avoid litigation. So a lot of different reasons. The three main types of organizations negotiate technology transfers in the corporate environment. There are your in-house technology licensing departments, which are working within the company. There are private firms, which act as agents for corporations. And then there are law firms, which act as agents or counsel to corporations. And as I alluded to, there are two main types of corporate licensing. There's what's called carrot licensing, which is where you make it clear to the licensee that you're not planning to assert the IP. And then there's stick licensing, which is where there is an implied or an explicit threat of litigation. And basically, settlement to an IP or patent litigation would be an example of stick licensing. MIT has a wonderful technology licensing office that manages the IP belonging to MIT. The director is Lida Nelson, who is also an MIT alum. And there are a number of MIT alums in the MIT TLO right now. She obtained her undergraduate and master's degrees in chem engineering and Sloan School of Management. And then there's Jack Turner, associate director, who obtained his EE degree here. And he's actually, we're lucky to have him in the audience today. So if you have any detailed licensing questions, I will tap on him. I will refer to him. Our TLO is one of the premier academic licensing offices, And it's in the much envied position that many potential licensees come to MIT. People, the name's been around there long enough, the reputation is great enough that people expect to find valuable new technologies at MIT, and they come to find it, and they will pay for it. There are approximately 200 academic licensing offices across the country, but only the top 20 are profitable. In other words, only the top 20 bring in more licensing revenue for the university or institute than they consume. MIT, of course, being one of the top 20, at the very top. And the overwhelming majority need to take proactive steps to successfully transfer their IP, unlike MIT, where there are a lot of companies that will just come of their own volition to see what MIT has to offer. MIT seeks protection for over 250, patent protection for over 250 inventions per year, and negotiates more than 100 license agreements per year. They tend to hire people with at least 10 years or more of business experience on top of a technology background. None of the people in that office have law degrees, which I thought was fascinating. One technology officer is registered to practice before the patent office, but is not using that background. They use a standard licensing agreement for most of their deals, and as with most other academic licensing offices, you can obtain this agreement for free on the web. Jack Turner, whom I spoke with, talked a bit about his career and how he transitioned to technology licensing. He joined MIT's TLO in 1993 after having accumulated over 25 years of experience in engineering and senior management positions at high technology companies. So he came already having a tremendous amount of experience. But he found through such business experience that what he liked the most was bringing new technologies to a business. And I guess he could see nothing appeal to him more than being at the technology licensing office. He came to see technology licensing as the ideal merger of business and technology, with some interesting legal issues as well. Some advice he has on deciding whether to pursue a technology licensing career. You have to ask yourself, what are the aspects of this area that appeal to you the most? Is it the business side of it, the technology side, or the legal issues? A technology licensing person must understand the technology and have enough business insight. And this insight is usually only gained through actual business experience, so that you can understand how a technology will fit into a business and what would the technology's value be to that business. If your interest is mainly in legal issues, then you probably don't want to go into technology licensing. I've also spoken with Joseph Cote, who is a graduate of the Sloan School here, and he is also in the audience today, so we're lucky to have him here. So if you have questions, you can also I also will refer to him as well. He has been working in IP strategy and commercialization for over 20 years. Before starting Cote Associates, which he currently runs in Cambridge, Massachusetts, he ran IP licensing for GTE Laboratories and Rockwell Scientific. He was the founder of IP Value Management, which is a very well-known IP commercialization and consulting company. And he was VP of IP commercialization and marketing for Arthur D. Little Enterprises. And prior to entering the field of IP, he held a number of positions in finance, management, and consulting. So you can see the amount and breadth of business experience that both of these people obtained. Some advice from Joe on deciding on technology licensing. If you're scientifically curious, it's a great opportunity to be involved in a broad range of technologies. A major motivation is the excitement of closing a deal, and it feels good to be potentially creating new jobs by bringing a new technology to a market. The main questions a successful carrot-type technology licensing person must answer for the potential licensee. Does the technology solve a problem for the potential licensee? Is there a value proposition that can be made to the potential licensee? It's best if you have a broad background that includes an understanding of finance, so you can deal with things such as term sheets, marketing, and technology. Further advice, he says specifically, before entering technology licensing specialty, you should obtain experience with business negotiations, and you can obtain this in a variety of ways. You could be an engineering manager, for example. So you don't have to have go to law school, certainly, and you don't even have to have obtained an MBA. Or you can be a team member in a company, for a company that's looking to acquire technology. And companies will often set up teams to do that. And the relationship between technology licensing and a legal background, Joe would describe technology licensing as legal affected or legal influence career. You do need to not know a lot about contracts and patent law. Legal advice supports technology licensing, but it does not run it. There's certainly no downside to already being a lawyer, and lawyers certainly do and have become successful technology licensing professionals. Now I'm going to go to career type 4, litigation specialist. First, I'm going to compare IP litigation to other types of careers presented. IP litigations tend to be large and complex, and therefore IP litigation is mostly practiced within what's called a large firm environment. So that's something you may want to think about, whether you want to have the option of working in a smaller firm environment. Its relation to the major modes of IP use, creation, enforcement, and exploitation, almost by definition, if you're a litigation specialist, your focus is on enforcement of IP. But it's important to keep in mind that the experience gained from past litigations certainly guide the creation of IP, very much so, and agreements for its exploitation. Furthermore, the threat of future IP litigation motivates IP's creation and exploitation. Also, since almost all litigations are settled, as opposed to coming with a final judgment, you have to have strong settlement skills. And anyway, in sum, IP litigation plays an essential role in keeping a market for intellectual property. And the alumnus that I'm addressing today is Avinash S. Lele, who is now a partner at Kirkland & Ellis. He describes litigation as involving two essential skills, problem solving and advocacy. And you need to be good at both, and you should really enjoy both if you want to go into this area. The problem solving is, there are two classic types of problems in IP litigation. There's a potential plaintiff scenario, and there's the potential defendant scenario. The potential plaintiff has some other party encroaching on their IP territory that should belong to your client. The potential defendant thinks that he or she has a right to provide products or services in a certain space and is being threatened with a suit. And you, as the lawyer, need to come up with positions that vindicate your client's position. Why is your client right and the other guy wrong? There are two classic perspectives in patent litigation. The plaintiff perspective, where you're seeking to prove infringement of some other companies that are infringing your IP, and you're trying to defend validity of, for example, your patents or your IP. On the other hand, if you are representing the defendant in a litigation, the defendant perspective, then you need to show non-infringement and why the products and services are outside the scope of the IP. And you also want to try to show invalidity. Why are the plaintiff's patents things that have already been done before, or that are insignificant contributions? So those two perspectives come together and clash before a judicial officer then decides who's right. You need to be very creative at the problem solving. This is a particular emphasis at Kirkland. You have to remember that your client has a business problem. They're not looking for a particular legal result. They're looking ultimately for a business result. You must look at the full range of, therefore you must look at the full range of potential favorable outcomes. And I thought Avi made among many excellent points, I thought two particularly excellent points that he made was that an MIT education teaches creative problem solving. And I think that's really true. And maybe you guys don't appreciate it so much now, but you will over the decades to come. And he says, and I think it's true, that if they don't have it before they start, by the time an MIT student graduates, they sort of have creative problem solving in their DNA. And so that's really helpful in really any of these careers, but certainly in litigation problem solving. The other half of it, of course, is advocacy. Since you are not the decision maker, you have to convince somebody else that your position is correct. The decision maker being a judge, which could be federal, state, or administrative law judge, and or a jury. And this involves brief writing, oral argumentation, and presentation skills, such as sophisticated graphics and computer animation, which has become very advanced. There are a number of why does a case settle or go to trial? That's an interesting question. Most companies would rather settle for a known amount than, quote, roll the dice at trial, because there's always uncertainty in a trial. However, you'll only get a favorable settlement for your client if you have come up with good positions, i.e. your problem-solving skills are excellent, and it's clear to the other side that you will be able to convince the decision maker of those positions, i.e. your advocacy skills are excellent as well. Cases will still go to trial for a variety of reasons. There may be no middle ground. For example, in the pharmaceutical area, management at one of the parties may have become invested in achieving a particular kind of result and feel they can't change their position. There can be skewed perspectives because both sides may not have an accurate understanding of the facts or the law. And there can also be just personality clashes between the companies. Avi's MIT experience, he obtained his BSEE in 1987, his MS in 1990. His technical interests in graduate school included communications, signals and systems, and information theory. Even as an undergraduate, he discovered that he enjoyed teaching, both as an instructor and a tutor. And while in the PhD program, he greatly enjoyed a teaching assistantship. So his transition to a legal career, once again, as with the other people that I've talked about, they did not attend MIT with any thought of being a lawyer. But he realized that he enjoyed persuasive writing, writing where there was a point to be made and where one is trying to prove something. And he made the connections through friends and general knowledge. He did not know about Robert Rines' discourse, that persuasive writing is an important part of practicing law. And he went into IP because he enjoys technology and learning about it. And he went into the litigation side because he enjoys its two main components, problem solving and advocacy. And as we alluded to before, an important part of litigation is therefore, and it's an ability to teach the decision maker. So there's an interesting analogy between litigation and teaching, that in litigation there are basically two teachers, the lawyers for each side in the classroom of the courtroom, and they're teaching competing views. But in this case, the student is basically the decision maker, and they reach a verdict on basically which set of teachers do they believe more. So, but it really is litigation really is a kind of super duper teaching. It's kind of the way I would put it, based on my experience. And Avi very much agreed with me. Particularities of practice at Kirkland is emphasis on creative problem solving and solving a business problem. You will not be pigeonholed into particular technical areas based on your technical background. And they only do litigation. They don't do prosecution, for example, or opinion work. Some advice he has for deciding if litigation is for you. Litigators live for the thrill of the courtroom. So, therefore, I think his advice makes a lot of sense. And I've never heard it before, but it makes a lot of sense. Go to a court and watch some trials if you think you might want to do this, because they are public proceedings. Anybody can do it. And you can go to a patent trial, and you can watch it. And things to watch for. How do the lawyers interact with the jury? How do the lawyers question witnesses? How is sophisticated technology, such as computer animation, used to teach? And remember, you're not trying to determine the merits of the case. You're just trying to look for these types of interactions. And ask yourself, are you excited? Would you be excited to learn the skills that you're watching? Do you think you could master those skills? I think that was a very good, very, very good advice. He also suggests visiting a law school early, before even starting to apply. And that's quite true. You can go watch a law school class. And if you find it interesting as an observer, it's only going to be more interesting if you're actually there as a student. Is there something about your life experience that indicates that you perform well in front of people, can think on your feet, and respond well in dynamically changing, unscripted situations? These are kind of key things to think about for litigation in particular, because while exciting, litigation is quite stressful and has many peaks and valleys. And if you need a steady work environment, for example, litigation is not for you. However, if you can stay calm in a stressful environment, that's a great asset. Can you, quote, roll with the punches that constantly buffet a litigator? He says, and I agree, do not try being a paralegal, because it's too low level and you really won't observe what would make you excited about being a litigator. And patent prosecution would not provide a window into litigation. Now I'm going to cover the last career type, outside IP counsel, non-litigation, which is what I do. And as I mentioned earlier, there's a broad range of potential responsibilities. Basically, you could end up doing anything that the in-house department is doing. But the work you do depends upon how each particular client approaches outsourcing. So you could be doing creation, enforcement, exploitation. Of course, in the enforcement area, since you're not a litigator, you're going to be doing counseling. You're not actually going to be going to court. But in creation, you'll be doing you can be doing patent prosecution, trade secret procedures, employment agreements. In the exploitation area, you can be drafting licensing agreements, or doing due diligence investigations. So a little bit about my background. I always had a great fascination with science and technology. I was awarded my first patent, actually, in high school. And I was a national finalist in the Westinghouse, now called the Intel National Science Search. Undergraduate, I made the big mistake of not going to MIT undergraduate, but I corrected it for graduate school. I pursued research opportunities as an undergraduate at the Cron Institute, in supercomputing, and at Bell Telephone Laboratories, and robotics and computer vision, and also with IC design. And then I spent some time in the PhD program here, first working in computer vision, then went with an MIT spin-off company called Symbolics, and what you call electronic design automation tools, chip design tools. Then pursued some research on concurrent computing, and finally settled with Professor Jonathan Allen and Professor Devadas in the EDA, Electronic Design Automation area, completing the master's in 1989. Then I actually worked with MIT's TLO. They actually filed a patent application based on my master's thesis, and I was awarded 2 patents on it. While I was working for Symbolics, for the spin-off company, it kind of sparked an interest in how business and technology issues interact. And while I was working on the master's thesis, I had a friend who was attending law school, and he told me about what was going on in IP. And I discovered that all aspects of my engineering background were becoming very relevant. I also saw that software protection, which had been up until then, had been always trade secret protected. Software patents were starting to become much more common. So I saw patent law as an attractive middle ground, and was also drawn to the fact that it would be a relatively scholarly career. For a JD, I attended New York University School of Law, which has a very strong IP program, started a Law and Technology Society. and so forth. I practiced for over 10 years with large law firms. For basically the first 5 years, I did almost exclusively patent litigation, which was a great background to be involved in, but realized I didn't want to stay with the litigation side of things. And then I spent 5 of those 10 years shifting to primarily non-litigation IP practice. Gained experience in Silicon Valley and was lastly a partner at Howery, Simon, Arnold & White, a major law firm. From 2003 to present, I've been running an independent practice and basically continuing the same non-litigation IP practice I developed from 97 to 2002, but in a small firm environment. And I continue to represent large companies, but I have more flexibility to represent startups, which I particularly enjoy. And I found that with a modern technology, it's easy to maintain a global practice even when you're a small firm. It's really changed things a lot. And I very much embraced using new technology to make my own practice more efficient. So in conclusion, I just want to leave you with the thought is you should look for, where's the, quote, juice in what you're thinking of doing? What is it that will inspire you to endure the drudgery that's going to be attendant to any profession? For a litigator, it's appearing in court. For a technology licensing specialist, it's closing the deal. For any lawyer, there's the satisfaction of knowing that your client needs you. My personal philosophy is that if you enjoy what you do, you will be good at it. And if you enjoyed today's lecture, then perhaps you're off to a good start. Thank you.